So without further ado, it is now my pleasure to introduce our next speaker, Laura Bevacqua. Laura is the Principal Attorney for the Mental Hygiene Legal Service in the Binghamton area. As a reminder, this session will be recorded for educational use at a later time. Laura?
Hello, good morning, everybody. I am going to, there you go, thank you, Lauren. Lauren's going to advance the slides, and I am going to be taking periodic breaks during the discussion for questions, and if you have any, please feel free to ask them as I'm going along. Lauren will probably cue me as questions develop. My name is Laura Bevacqua. I'm an attorney with the Mental Hygiene Legal Service. For those of you who are not familiar with the Mental Hygiene Legal Service, we are a state agency that provides legal advocacy for individuals with developmental disabilities. Our agency provides oversight for individuals regardless of their residential status, but there has to be some nexus to OPWDD. So we provide advocacy for individuals that are in developmental centers. There's only a couple left in the state. We also provide advocacy for folks that are in group homes, both state operations and with voluntary agencies, and then also for individuals that reside on their own, but have outpatient services through OPWDD. Next slide, please. So healthcare decisions for folks with developmental disabilities have, as we know, have particular requirements, some challenges. The type of considerations that have to be made are somewhat dependent on their residential status, but more so on just the types of decisions that people make, and also how healthcare providers react to an individual's choice, and whether or not a healthcare provider is going to recognize the consent of that particular patient. Next slide, please. So the Surrogates Court Procedure Act, Article 1750B, was enacted for to allow surrogates and legal guardians the authority to make healthcare decisions, including end-of-life decisions, for their family members, even if their wishes were not previously known. Prior to the enactment of the Surrogates Court Procedure Act, all individuals who had developmental disabilities who resided in certified settings were not able to make those decisions. The family members were not able to make those decisions unless the person, the patient themselves, had made a prior competent decision. So the 1750B, which is part of the Surrogates Court Procedure Act, did become available for legal guardians. Prior to 1750B, a legal guardian could not withhold or withdraw life-sustaining treatment unless, of course, as I stated, that the patient had made a prior competent decision with respect to the withholding or the withdrawal of life-sustaining treatment. So it applies to all individuals who are developmentally disabled who lack the capacity to make healthcare decisions regardless of their residential settings. So if a patient is, regardless of whether or not they live in a group home or they live on their own, the 1750B end-of-life OPWDD checklist applies. The only exceptions for this process are individuals who can make their own healthcare decisions or individuals who have previously validly executed a healthcare proxy. Next, please. So what is a healthcare proxy? A healthcare proxy allows an individual to elect or assign another individual to make healthcare decisions on their behalf. And anyone is in New York State, every adult is presumed to have the capacity to execute a healthcare proxy. And healthcare proxies for individuals residing in OPWDD operated or certified settings can execute the proxy if they understand that they are delegating to another individual the authority to make healthcare decisions. Now, that ability is not necessarily the same standard as having the capacity or having the ability to consent to healthcare decisions. So you might be working with somebody that is not able to make healthcare choices, but they are able to appoint or assign a healthcare agent and consequently execute a healthcare proxy. For the purposes of the folks that we work with, there should be some documentation, conversation with the psychologist, with a healthcare provider that's able to discuss this with them. And it's really best to try to have contemporaneous assessment and documentation of that conversation in the event that there's a question somewhere down the line. Next, please. So the healthcare proxy, in order for it to be valid for our individuals, it has to be signed and dated. The signature doesn't necessarily have to be a formal signature. Some of our folks can only make a mark, and that's sufficient as long as it's witnessed by two adults. One of the adult witnesses cannot be the agent, and the one witness cannot be somebody that's affiliated with the facility. So if you have, if you're executing the proxy in a doctor's office, for example, you could have one of the witnesses be a staff person from the medical office, and the other witness must be either a licensed physician, a nurse practitioner, or a physician's assistant or clinical psychologist who is either employed by the DDSO for at least 1 year, employed by an OPWDD facility for at least 2 years, or have specialized training in developmental disabilities and has at least 2 years experience treating people with developmental disabilities, or has at least 3 years experience treating persons with developmental disabilities. Now, when it comes to the witnessing aspect of it, both witnesses have to be present at the time that the healthcare proxy is being executed. And the law did change in June of this year to allow a physician's assistant to be one of the witnesses. And also the clinical psychologist who is, if that's a witness, does not have to be a licensed psychologist. I know that within the DDSO that where we work, some psychologists are not licensed, but they're appropriate witnesses. Now, I had a situation recently where I was presented with a review of a healthcare proxy where the legal guardian executed the proxy on behalf of their daughter. And that is not valid. Only the individual patient can execute a healthcare proxy. A legal guardian cannot execute a healthcare proxy. And there's really no prohibition from the individual appointing their guardian as a proxy, but if they have a legal guardian, they really should not be executing a healthcare proxy. If you do have a conflict where you have an individual who wants to execute a healthcare proxy and it's somebody other than the guardian, then you really have to look at the decree, because if the decree authorizes a guardian to make healthcare decisions, including the withholding and withdrawal of life-sustaining treatment, then the guardian would have that legal authority. Now, before the healthcare proxy or the agent can act on behalf of the patient, there has to be a determination that the principal, that the patient themselves lack the capacity to render their own medical decisions. And also, and importantly, when you're looking at a healthcare proxy, there's the section at the bottom of the page that asks whether or not the agent has, or excuse me, the principal has any preferences regarding the withholding or the withdrawal of artificial nutrition or hydration. If that section is left blank, the agent does not have the authority to withhold or withdraw artificial nutrition or hydration unless the preferences of the patient can be reasonably ascertained. So if you do have somebody who maybe has had that discussion in the past, but there has to be some way of knowing what the patient would have wanted. If there's no way of knowing if that's something that hadn't been previously discussed and that section of the healthcare proxy is left blank, then the agent would not have the authority to withhold or withdraw artificial nutrition or hydration. Next, please. So the role of the mental hygiene legal service is to advocate for the patients, to investigate the prior and current circumstances of the individual, to contact the family members and staff familiar with the patient, and in addition to other medical providers, explain the laws and the process to the interested parties to ensure compliance with the statutory and regulatory requirements, and to initiate any legal action when appropriate. So to go back to my earlier example, when I was speaking with the family whose individual resides in a Racker home, this was a family member who had obtained legal guardianship. And they were pretty distressed that they were not familiar at all with the 1750B process and didn't understand why, as legal guardians, they even had to go through the process, having thought that they had this authority under the guardianship decree. One of the things that, because the law has, I don't want to say it wasn't newly enacted because it's been enacted for a number of years now, but this particular parent that I spoke to had had the guardianship decree since the mid-1990s, and at that point the 1750B process was not part of the Surrogates Court Procedure Act. And it's unfortunate that so many individuals who become legal guardians since the enactment of the law aren't aware of it, and or even if they had an attorney represent them in Surrogates Court, weren't made familiar with the process. So part of what we do, a big part of what we do, is to speak with the family members and explain the legal requirements of the law and why it does pertain to that particular patient and why we have to go through the process even if they have a legal guardian. Next, please. So what is the definition of life-sustaining treatment? It's medical treatment, including cardiopulmonary resuscitation and nutrition and hydration provided by means of medical treatment which is sustaining life functions and without which, according to a reasonable degree of medical judgment, the patient will die within a relatively short period of time. Before I move on, does anybody have any questions? Because I see there's a couple questions in the chat box.
Hi, Laura. Yeah, do you want me to read them out loud, or do you want to? I got it. So the first question is, Can they write in the section under artificial nutrition, HCP will decide about artificial nutrition at the time based on current prognosis and medical decision with provider at time, leaving it open for them to make a decision later in life based on the individual's wishes?
Yes, you can have that, but there has to be, what I would recommend in that type of circumstance is actually to have the individual who's executing the proxy in that moment to have some sort of discussion or have some sort of documentation right in the healthcare proxy, whether or not they want to receive artificial nutrition or hydration. If the way, I understand the question, and I think that I would prefer that it didn't read as though the healthcare agent was making the decision regarding the withholding or withdrawal of the artificial nutrition or hydration. It's really up to the patient themselves. So what you can add is because the person could have a preference, and I think that depending on the severity of their illness, they could have different preferences at different points of their illness. So it's probably better to have something in there from the agent, or excuse me, from the principal instead of the agent, saying that either they give authority to withhold or withdraw, or they have a preference about the artificial nutrition and hydration in particular types of circumstances. You know, somebody who is terminally ill may not want to go that route, but somebody who is maybe has a constellation of symptoms or medical problems would want to do that if it's going to prolong their life and maybe help them recover with their other medical illnesses. And with respect to the most, because I know this question came up before, and I just wanted to address that, because the guardian can change their mind, even if they've executed a most. If the guardian is the consent provider, they can request life-sustaining treatment that was previously decided not to be in the person's best interest. But in order to do that, they should rescind their consent. The most is a pretty rigid form, and the options are, when they're reviewed, are either reviewed with no changes, or there's a change, so that means a new form is required, or it's the elections are rescinded without a new most to replace it. So if a guardian does change their mind based on the circumstances, and I know it can be very difficult for a consent provider if it's not the patient to, depending on their circumstances, it can be very, very difficult. But the guardian certainly does have the ability to change their mind to provide consent where they previously felt that a life-sustaining treatment would not be appropriate. But you do have to change the most. Any changes in the most require a new checklist. Okay, thank you. I hope that answered the question. Next, please. So if you look at the checklist, I'm going to just refer to it because the way the checklist is set up, the presentation follows the checklist in terms of the order. But the first thing you should look at is whether or not the individual has the ability to make healthcare decisions for themselves, including withholding and withdrawal of life-sustaining treatment. If the patient does not at that moment, then you have to look at whether or not they've executed a healthcare proxy. If they have not, then that's when you go to the surrogates list. And there are also circumstances that I've encountered, and some of the providers who are watching this may also have encountered, that some medical professionals are not willing to accept the consent of the patient themselves, even if it's been explained that the patient had been spoken to by a psychologist or another care provider within the group home, and a determination has been made that the patient can make healthcare decisions for themselves, sometimes the doctor's not willing to accept that. You know, there's really nothing, I'm not sure what you can do about it. I mean, you can't make a doctor accept a consent any more than we can ask a doctor to perform a medical service that they're not willing to perform. So when you look at the surrogates list, it's in the order of preference. So the first person to look to if the individual does not have the ability to make their own decisions is a court-appointed guardian with the legal authority to make a healthcare decision. So some guardians are only property guardians. So if you have a guardian that is, you have to look at the decree to make sure that they have the ability to make healthcare decisions. And also the decrees, at least the ones when I work with individuals, their families, and the surrogates court, we usually ask that the decree include that 1750B requirements be followed, including the notice provisions, which I'll get to a little later. So if there is no legally authorized guardian to make healthcare decisions, you look to see if the individual patient has a spouse, an actively involved parent, actively involved adult child, adult sibling, or other family member. Now, actively involved is, that was a question earlier in the presentation, and that could be, it should be somebody that is familiar with the patient. It should be somebody that has regular contact with the patient and also with the facility if the person resides in a certified setting. But we do have individuals who have legal guardians and maybe they've moved out of town. The parent, it could be a parent who's elderly and maybe has some of their own medical issues and are not as involved as they had been. And sometimes I think a team has to look at what are the circumstances of that particular patient to determine whether or not the family involved is still actively involved and still appropriately actively involved to make these determinations. Now we do have a number of people who are represented by the Consumer Advisory Board, their Willowbrook class. Some folks are duly represented. They have both Willowbrook, the Consumer Advisory Board, and a family advocate. So in that particular case, either party could make the decision. If otherwise, there's also the Surrogate Decision-Making Committee. That's for somebody who has either no involvement with the Consumer Advisory Board or no actively involved family member and no legal guardian, or a court of competent jurisdiction. Let's see, we have a question. I think this is about, it's for Dr. Dewancik, so we'll save that question for Dr. Dewancik later. Next slide, please. So I'm going to talk briefly about the role of the Surrogate Decision-Making Committee. And this is for, again, for an individual who has no guardian or no actively involved family member and is not an individual who has representation through the advisory, Consumer Advisory Board. In this type of situation, the surrogate decision-making can be used for the purposes of providing consent to the withholding and withdrawal of life-sustaining treatment. And the Commission on the Quality of Care, the Justice Center, is now the agency that oversees surrogate decision-making. Next, please. So 1750B was amended in 2008 to permit the Surrogate Decision-Making Committee to serve as surrogates for people with developmental disabilities with respect to the withholding and withdrawal of life-sustaining treatment. However, the law was not amended to include major medical treatment for individuals who are mentally ill, who lack capacity without a surrogate and may have life-sustaining treatment withheld or withdrawn. Next, please. So once a person is eligible for life-sustaining treatment, they can continue to receive surrogate decision-making authority regardless of any change in residential status. And this is the statutory basis for MHLS to appear for surrogate decision-making proceedings, even for individuals who have been discharged from an OPWDD licensed facility and who are now residing in nursing homes. So while the individual is still subject to surrogate decision-making, MHLS is also required to receive notice for these proceedings. Next, please. So the surrogate decision-making regulations are in Part 14 NYCRR, Part 710. And the hearings regarding proposed withholding or withdrawal of life-sustaining treatment, the panel has to determine whether there is clear and convincing evidence that the patient is in need of surrogate decision-making by considering the certification of the attending physician and the consulting physician or licensed psychologist as set forth in the regulations, and consider each factor that is in the declaration and in the papers provided. And you can have up to three panel members that they have to concur the determination of the patient is in need of surrogate decision-making, and that the patient shall be deemed not to need the surrogate decision-making. One of the things I want to just add about the surrogate decision-making, the law requires to have either you're supposed to have 4 panel members. If 4 panel members are not available, then the minimum requirement is 3 panel members. And there, with COVID, it's been a little tough because we've had so many virtual hearings. But we've been able to have the virtual hearings that also include the patient themselves. If they're at home, it could be with use of technology that's available in the group home, or some of the hospitals that we work with have just been terrific with being able to provide technology so that the patient can also be visible virtually, and the panel members can also virtually visit with the patient, because they are required to visit with the patient prior to the panel meeting for to hear the request for the medical consent. Next, please. So the hearing regarding the proposed withholding or withdrawal of life-sustaining treatment, if the patient has been determined by the panel to be in need of surrogate decision-making, so they would look at whether or not the patient does have an appropriate surrogate. If an appropriate surrogate is found, or there's one that exists, then the surrogate decision-making committee suspends the hearing. It doesn't proceed if there's an alternative surrogate. The panel makes the determination whether the proposed end-of-life decision is in the best interest of the patient based on a fair preponderance of the evidence. The decisions to withhold or withdraw life-sustaining treatment pursuant to 1750B of the Surrogates Court Procedure Act shall include a consideration of the following additional factors. The panel cannot make a decision that is intended to permit or assist with suicide or euthanasia. The panel's decision shall be based on the patient's qualifying medical diagnosis other than developmental disability, with the recognition that a person with a developmental disability is entitled to full and equal rights, equal protection, respect, medical care and dignity afforded to persons without developmental disabilities and without any financial consideration as such as may affect the healthcare provider or any other party. Okay, so I got another question about a healthcare proxy. How do we know which licensed physicians, nurse practitioner, physician's assistant, or clinical psychologists in our areas are qualified to assist as being a witness for a healthcare proxy? So it has to be somebody who has, if we can go back, Lauren, I'm sorry, can we go back a few slides? Because the law is pretty specific with respect to the healthcare proxy. Let's see, okay, so this is my slide number 6 on healthcare proxy. And the requirement for whether or not a doctor, nurse practitioner, or physician's assistant or psychologist has the appropriate credentials to be a witness for one of our individuals. It has to be an employee of the DDSO. So if it's an individual who resides in state operations, that makes things fairly easy, because if you live in a facility, inpatient facility, then you already know that either the physician, the nurse practitioner or physician's assistant or psychologist is going to be somebody that already works for the DDSO. If it's somebody that's in that resides in a voluntary agency, an appropriate clinical psychologist could be a psychologist that works for state operations. It could be somebody that has worked with people with developmental disabilities. I mean, you really have, if you don't know the doctor, if you're going to a primary care physician's office, that person has to have either the specialized training through working with people with developmental disabilities, and have at least 2 years experience treating persons with a developmental disability, or they have to have, if they don't have that specialized training, then they have to have at least 3 years experience treating persons with developmental disabilities. If you don't know, you would have to ask the doctor. And perhaps that doctor's office may not be the best place for that patient to execute the proxy if they, if you're not sure. You mean it could always be executed at any location. The healthcare proxy doesn't have to be executed in a medical office. It could be done in the person's home. But you still need to have the correct witnesses in order for it to be valid. How do you identify them? Well, I'm not sure how else to answer that question, because they're identified by, they have to meet these, one of these criteria. So if you are in a medical office and you're working with a nurse practitioner or with a physician's assistant, you have to ask them, what is your experience with respect to working with people with a developmental disability? So if you have somebody that you know that you've worked with for many years, I think that's somewhat self-explanatory. And then the second witness could just be another person in the office. It doesn't have to be, this criteria is only required for one witness. It's not required for both witnesses. Okay, so if we can move back to, say, slide. number 14. Okay, thank you. So as I was saying earlier, once you have surrogate decision-making in place, you have to have at least 3 members, and they have to concur with respect to the request that is before the panel. Next, please. So a hearing regarding the proposed withholding or withdrawal of life-sustaining treatment if the person has been determined. Oh, I'm sorry, I did this one already. Next, please. Okay, thank you. So the surrogate decision-making forms can be found at the following link. And also, just as a reminder, that after you've completed the surrogate decision-making, so once the panel has rendered a decision, the checklist is still required. The panel acts as a surrogate for that patient who doesn't otherwise have a family member or legal guardian, or they're not subject to Consumer Advisory Board. So that consent is only that, the consent. So once the consent is provided, the checklist is still required, and it still has to be completed, and the notifications still have to be made before that consent can take effect. Next, please. So I just wanted to go over a couple of things regarding hospice. So hospice is now part of surrogate decision-making, and you can request consent for hospice through the Surrogate Decision-Making Committee. And then following the hearing, that was actually, I want to just back up a little bit. This was an area where up until recently, until the Surrogate Decision-Making Committee could hear these, the requests for consent for hospice, hospice providers would often contact my agency and ask, who's going to consent to hospice? If the individual does not have an authorized surrogate, and you're going through Surrogate Decision-Making Committee for consent for the withholding or withdrawal of life-sustaining treatment, and there really wasn't anybody. So with hospice now being part of this process, it does allow a separate hearing if this was not part of the original request for consent for hospice care. Now, hospice is considered major medical treatment, but is usually joined with life-sustaining treatment depending on the person's circumstances. So hospice in and of itself is not the withholding or withdrawal of life-sustaining treatment, because hospice requires that care be provided subject to the checklist and the MHLS. Next, please. So the surrogate's responsibilities are to advocate for treatment and to base their decisions with respect to the person's best interest when known, and their wishes, including their moral and religious beliefs. Next, please. So best interest, to determine the best interest for that particular patient, look at the dignity and uniqueness of the person, to preserve, improve, or restore health, relief of suffering, the unique nature of the artificial nutrition or hydration, and the entire medical condition of that person. Let's see, before I move on to the role of the physician, I just wanted to check our questions. So the question is, it sounds like healthcare proxy and most qualifying providers differ. Only an MD can sign off on the most, which is correct. And the PA or the physician's assistant or nurse practitioner, even though the nurse practitioner and physician is their primary care physician, doesn't one of the physicians signing have to be OPWDD certified? Well, there is a distinction between the healthcare proxy and the checklist. I want to stick with the checklist first before we get to the most. The checklist, when I get to, and I'm going to be talking about the physician's role next, the checklist requires the attending to make a determination whether or not there's the appropriate medical criteria, whether or not the patient has meets the appropriate clinical criteria, and that has to be verified by a second concurring physician. So while you can have a healthcare proxy that's witnessed by a nurse practitioner or a physician's assistant, if they meet the criteria, the checklist does require that there be an attending physician, such as a primary care doctor, but then there also has to be a concurring physician for the purposes of the clinical evaluation. And with respect to the issue of capacity, the physician makes a determination as to whether or not the patient has the capacity to make a decision regarding the withholding or withdrawal of life-sustaining treatment. And then if the doctor determines the patient does not have capacity, that capacity has to be then reviewed. That determination has to be reviewed by either a psychologist or a medical doctor who is, if it's a psychologist, it has to be a licensed psychologist or a medical doctor that is, that does have special training working with people with developmental disabilities and has that designation by the commissioner of OPWDD. Next, please. So when completed for a person with developmental disabilities, the 3-page checklist is required to accompany the most, excuse me. The approved checklist indicates the necessary findings for statutory and regulatory compliance. So actually the checklist, and what's nice about the checklist is that it follows the law. All of the information that's in the checklist are legally required by 1750B of the Surrogates Court Procedure Act. Next slide, please. So the role of the physician, as I just stated, is to determine whether or not the patient has the capacity. And then they have to arrange for a second opinion with respect to capacity by OPWDD qualified licensed psychologist or physician. Next, please. If you look at the OPWDD website, there's information about providers, and they've updated the website to include response to COVID. Next, please. Under 1750B of the concurring capacity determination has to be made by a psychologist or a physician with special credentials. As I had stated earlier, it has to be somebody that is either, it has to be somebody that's both familiar with OPWDD individuals and also have that designation by the commissioner. In the event that the provider is unable to provide a concurring opinion and the hospital doesn't have a clinician who meets the necessary criteria, there is a hotline that's available through OPWDD. Every hospital in our region is different. Bassett Hospital in Otsego County has a number of physicians that are have been trained and certified by the commissioner. Locally, I think that there are not many. So usually what happens if one of our individuals is either at a UHS hospital or at Lourdes Hospital, they will reach out to the local DDSO to see if maybe one of their psychologists can act to perform that capacity determination. Next, please. So then the doctor has to certify that whether or not the patient has a terminal condition. So this is the second page of the checklist, and this is really the critical clinical portion of the checklist, where the physician has to identify whether or not the patient has a terminal condition, is permanently unconscious, or has a medical condition which requires life-sustaining treatment, is irreversible, and which will continue indefinitely, and that the proposed treatment will impose extraordinary burden on the patient. So all of these criteria have to be met in terms of the patient has to have either a terminal condition, or is permanently unconscious, or has the medical condition that requires life-sustaining treatment, and the proposed treatment would impose an extraordinary burden on that patient. Next, please. The doctor has to, in determining whether or not the patient will suffer and the risks or the burden outweigh any benefit to the patient, you have to look at the overall medical condition of the patient and the expected outcome of that particular treatment. Next, please. Now, with respect to artificial nutrition and hydration, this is an area that causes a lot of concern. It's very difficult for both family members who are providing consent to withhold or withdraw artificial nutrition and hydration. It's very difficult on care providers, especially if the expectation is that the patient is going to return to either their family home or to a certified setting for care. It's often difficult to make that decision, but you have to look at whether or not there's any reasonable hope of maintaining life, or if artificial nutrition and hydration would pose an extraordinary burden on that patient. An individual who has a terminal condition, whether or not they choose to, or the choice is made to withhold or withdraw artificial nutrition or hydration, really is not going to impact that patient's overall outlook. It may hasten their demise if they have a terminal condition, but it certainly isn't going to cure the condition if you do introduce artificial nutrition or hydration. A lot of our folks already have, they're already receiving their nutrition via G-tube. I think it's important for us to remember that our experience with our folks is different than what some healthcare providers may encounter. For a hospital setting, UHS is becoming much more knowledgeable and more comfortable with our patients because it's been so many years that we've gone through this process with them. But an individual that goes into the hospital or is diagnosed with a terminal condition or has some other catastrophic or chronic medical condition that may already have a PEG tube put in, for that individual, you may be having to face the decision as to whether or not to then withdraw the artificial nutrition or hydration. And that can be very difficult. So you have to really look at the overall picture. But I think that sometimes, and Dr. Dwancik talked about this earlier in his presentation, is that you have to look at the overall picture. What benefit do you hope to gain by either introducing the artificial nutrition or hydration, or what is going to be the burden on that patient if they don't already have this as their means of nutrition. Next slide, please. So if the checklist has been completed, then you have to look at whether or not the individual resides in an OPWDD licensed facility or if they reside at home. If the determination was made to withdraw treatment, so this is maybe somebody that's on a ventilator and you want to withdraw that treatment, then prior to the withdrawal of the life-sustaining treatment, you have to provide notice at least 48 hours prior to the withdrawal of the treatment, or as soon as possible if the request is to withhold treatment. So withholding treatment, an example would be withholding of CPR. So the notice is a little bit different, depending on whether or not you're withholding treatment or withdrawing treatment. Next slide, please. And who is required to receive notice? The patient. The patient should receive notice. There should be some, if possible, some communication with that patient. If the patient does not receive notice, there should be documentation that the doctor has determined why that patient has not received notice. And this is an area it's a little frustrating for us at MHLS because we often find that the patient has not received notice and there's really no determination made as to why the doctor felt it was inappropriate to provide notice to the patient. But it does say in the checklist that there has to be a therapeutic exception to the to notice to the patient, and that could be that either if they don't understand because their developmental disability precludes them, or because it could be also because the specific condition of the patient. If they are permanently unconscious, clearly that's going to be an exception to providing notice to the patient. But the patient should be involved in this communication. So the CEO of the facility, if the person resides in a OPWDD certified setting or nursing home, MHLS, if the person resides in a facility, or the commissioner of OPWDD if the patient is not in a certified setting. Next slide, please. So notice for individuals who are in state operating residences can be provided by contacting the OPWDD hotline. Notices for individuals who do not reside in OPWDD operated or certified settings should also go through the hotline. And for people in certified settings who are not operated by OPWDD, then the director or the executive director of the voluntary agency residential service provider, they are the ones who would receive notice. Next slide, please. So who can object to that determination? The objection can come from either the patient, a parent, the adult sibling, other healthcare providers, the director of the facility, the mental hygiene legal service, or the commissioner of OPWDD. So I just want to be clear though that you would be, if there's going to be an objection, the objection is to the determination to the withhold or withdraw of the life-sustaining treatment. There can be no objection if there's no determination made. So if you don't have either the individual family member or legal guardian or surrogate decision-making, if there's no consent provided to withhold or withdraw life-sustaining treatment, there can be no objection. It has to start with the consent. And I'm bringing that up because I did have a provider once ask me whether or not they could object to the lack of consent provided. And the answer, of course, is no. if there's no, if there, the provider, if the provider feels strongly that end-of-life treatment should be either withheld, or excuse me, I should rephrase that. If life-sustaining treatment should be withheld or withdrawn, but either the family member, the guardian doesn't agree with the doctor, there's nothing for the doctor to object to, because you have to have that consent in order to even go through this process. Next slide. I think that's it for me. So the objection suspends the decision of the surrogate to withhold or withdraw the life-sustaining treatment pending judicial review or dispute mediation. The objection to the healthcare decision, the suspension, a healthcare decision pursuant to the subdivision 4 of this section shall be suspended. So if there are any objections, then obviously then the withholding or withdrawal of the life-sustaining treatment cannot proceed. Next slide. Okay, thank you. I don't know if there are any questions left for me.
I think that we've answered them all at this point, Laura. Thank you.